Hello, welcome. It's Rick Bukata. It's that time again. Risk Management Monthly coming to you with Rachel on the line and Greg. Uh, Guys, welcome. Hello. Anything going on in your lives?
Just the usual snowstorms here in Michigan at this time of year. Other than that, okay, Rick.
Well, we are streaming this, and so Greg, you can't see Greg's face because we don't have his microphone lined up with his computer, but audiologically he's perfect. So
Okay.
what are you going to do? So Greg, every once in a while, just look at that camera just to let us know you're there.
Yeah.
Um, Rachel, you just got home from a meeting. Are you basically kind of starting to run that department, or at least?
No, we're doing a boot camp for the graduating fourth year students. So we have them in the simulation center and we're running them through all these like mock codes.
So that boot camp term is copyrighted and
oh yeah,
trademarked, and
I think ours is
yeah.
the original. So you can pay us the
We,
royalties
we've been
anytime.
doing boot camp for like 9 years. But anyway, guys, it's time to begin. We got a bunch of interesting stuff that we're going to review. And listen, Ricky tells me we're live streaming. So listen, if you want to send in a comment, question, disagreement, do that. And I will actually look at my monitor here and maybe we can answer these questions if you send them in. But if there's only two people listening, I don't expect much. In any case, let's get started with the smell of alcohol on somebody's breath at work. Rachel, that's
Oh, that's me.
that's
All
you.
right.
Yeah, I'm sorry.
I'm on it. I missed
Sorry
my
to
cue.
interrupt.
All right. So this was a story of an OB-GYN physician who basically went to work and a nurse practitioner there thought that she smelled alcohol in this physician's breath. So later, the nurse practitioner sent an email to one of her supervisors saying, I think this physician smelled like alcohol. And eventually this email worked its way up to the CMO of the hospital. And they got together and talked to a group of other physicians. And, without the physician whom this was about being present. And these other physicians said, well, this was actually brought up a few years ago, kind of the same issue about alcohol. And so they went back to this doctor and said that we're going to suspend you with just partial pay until we figure out what's going on. The doctor denied this, said I didn't have any alcohol, and basically sued, saying, now I've lost my income. I've had to, fork over all these out-of-pocket expenses, caused me a bunch of emotional distress, and really damaged my reputation based on these false allegations. Went to court on this and ended up being awarded almost $6 million. And really the reason for this, based on the court's ruling, was that the hospital had a policy based on how they were supposed to handle allegations like this, and it wasn't followed. The doctor wasn't advised at the time of the incident that there were any suspicions about their behavior, that the employer didn't assess the doctor at the time of the incident, didn't do a breathalyzer or a blood alcohol or anything like that, didn't send the doctor home at the time, didn't relieve them of their duty like they were supposed to. It was really after the fact that they got suspended. Let's see, the doctor was not requested. The doctor didn't have the ability to be have the request to be tested for alcohol in an independent laboratory. That was part of the policy. It was written that they had the ability to request that. And that, kind of based on the fact that there was this policy in place that wasn't followed at all, the doctor, none of these things should have happened. And so the court really favored, the doctor's argument here and gave her almost $6 million.
Yeah, I think we're all often in the situations, particularly when we're on call and it's the evening and you're calling in a doctor and it's Saturday night and they're on call, but they might have had a drink or two at some kind of dinner or cocktail party, and they come in. And I mean, I've had this happen over my career. Greg, you ever have any people you thought were mildly intoxicated?
Yes, and let's get right to it. It doesn't make you any friends to have to pull a doc into the next room and talk about this, but you know what? You don't have any other choice. And if there isn't a hospital policy about it, there needs to be, because it is going to happen, Rick.
Oh yeah. Rachel, you ever have anybody do this in your young career?
I haven't yet, but it's a baby career. So I think that I can obviously see, what an easy situation this would be to be in.
It would be interesting to know what the policy is at your hospital, but this is one of the times where you must follow it to the letter. And these guys screwed it up from the get-go. And you would think some supervisor who was made aware of this that evening, I mean, would have handled this, but the NP didn't even do that. And so you can see that this doctor's reputation was harmed, and they weren't able to show that she was intoxicated at all. And so it's like, I think that, she won a good case, but everybody just dropped the ball here. I can see, going to an outside lab, but are you going to do that at 10 o'clock at night? I'm going to send you to an outside lab to see you've got alcohol in your bloodstream or some other drugs. I mean, that's not a very practical thing to do. So I'm not sure how that would be applied, but the the lesson here, I think, is you better know what your hospital's policy is, because this is something that is important. If you let the doctor stay on, for crying out loud, and there's some harm done, can you imagine the liability associated with that? In any case, that was the case of the doctor with alcohol on her breath, who basically doesn't have to work for a few years to recover from the anxiety associated with this and emotional distress and loss of consortium.
Yes.
There's another article in Medscape on more on the recording of doctors. And this is interesting because it basically said that the AMA recently tabled a proposed resolution that any recording of a doctor would require the agreement of both parties. It's like, what is the AMA thinking about? They're not the determinants of what a person can do or not do. It's the state law that is the determinant here. So the AMA basically kind of was going to overstep its bounds anyway. They have no authority here. Remember from past discussions that 39 states require only one consent, and that's the consent of the person doing the recording. That's all they need.
Absolutely.
They have to ask themselves, "Are you consenting to record that doctor?" And if they say yes to themselves, has this ever happened to you, Greg?
No.
Anybody ever? Well, not that you know of.
Well, it's never happened that I know of, and I've never seen a legal action filed or taken against an emergency doc based on a recording made in any of the emergency departments that I've worked at. Now, whether it has actually been contemplated or not, I don't know, but I think it's still got to be a fairly rare event, Rick. It can't be a daily kind of event at the emergency department.
Well, a Dartmouth study said that 1 in 10 patients record their visits, and now that when you were working in the ER, a tape recorder was about a 1 foot square box.
Right, exactly.
Now the tape recorder is in your pocket as your phone, and you just turn that sucker on, and it's in your upper pocket, and you've got everything down except the video. I want to read the 11 states where you have to have two parties' consents, and this is where the doctor does have the opportunity to say, "I don't agree with what you're doing, and you don't have my permission. And if you continue to do this, it's against the law of the state of California, and we're going to get you for that." And those 11 states are California, Delaware, Florida, Illinois, Maryland, Massachusetts, Montana, Nevada, New Hampshire, Pennsylvania, and Washington. And if you're in one of those states, you're in kind of a states that are kind of smart, because the idea of one state, 39 states, how would you get a law like that passed, that you don't need anybody's permission to take their picture?
Yeah. I don't know of, obviously, my state of Michigan is not included in that group, but I've never seen over my 40-some years of doing emergency medicine, I've never seen the case in Michigan where a recording was used against an emergency physician. I've never seen it. Now, it may be out there somewhere, but you know what? This has got to be pretty rare, Rick.
Well, this is not a malpractice action. This is a some kind of civil or no criminal action. But in any case, what do you think, Rachel? Do you think that you care much about being recorded or not? What if somebody comes in and say, "I'd like to watch you record you suturing up my little Johnny here"?
I mean, it makes me a little uncomfortable, but it's probably not a hill I'm going to die on.
Oh, okay. You think, okay.
And, as far as it feeling a little bit wild that states would let you, record somebody without their permission. I guess the other argument for that is, you have, as a patient, you're paying somebody to provide a service for you.
Hmm.
And the physician has accepted, the other end of that contract, that money to provide that service. And so if that comes with the acceptance of, the agreement that they can then record you, like, okay, in those states, it comes with that too. It is what it is.
Yeah, I guess that's true, but I think that once you have determined that there is not a medical emergency as defined by the Healthcare Financing Administration, your EMTALA duty is over, so that you could say, Mrs. So and so, my obligation to treat you now is over, and unless you discontinue this recording, I'm going to ask that you see another physician. Because and I think you would have every right to do that. I don't think you would do that, but I think that would be within your rights to do that.
Yeah, it would be. And then, but we don't do that regularly. And we
No,
also, and then we continue to bill them for all the stuff we do after our EMTALA obligation's over.
the
We regularly extend our contract with them past the EMTALA obligation for our benefit,
Yes.
not thinking about it as if it's for our benefit, but we do.
they say this stuff could be shared on social media. The potential for editing the recording is there. Disagreements over some pandemic related issues. You refused to give ivermectin to my husband, and now look what happened. And I recorded that you didn't do that. In any case, it doesn't seem like it's a really big issue, but I do know that I remember people who came in and recorded stuff, and I think you need to know what your rights are in that regard. I don't think you want to be a jerk about it, but I also think if you feel particularly uncomfortable about it, then I think you need to basically let the person know that I'm happy to take care of you, and I'm going to commit to doing as good a job as I can, but I must tell you that this recording is making me feel very uncomfortable.
I do
Uh,
think there's room for institutions to step into, and
oh yeah,
I would have to
absolutely.
think about how that would play out, a potential conflict with these state laws. But, I think institutions can say, we don't allow recording in these settings.
Yeah, I think that that's true. The person could say, well, actually the law does allow me to do that if they knew the law. But I've always basically said that the hospital should have a really nice sign, big, on the wall that says, for the protection, for the privacy of our patients, no recording is allowed in the emergency department, because you always have the opportunity to hear, other things that are going on that are frankly not your business. And in ERs that are old, that still have curtains between people, like an ER that I'm familiar with, the last 25 years had curtains between many of the patients. I mean, those curtains are not odor proof and they're not soundproof. And it's like the idea that a curtain in any way provides privacy is kind of a joke. So I think that that's another issue, the privacy of the other people in the department. But shall we move on? Any comments, questions, disagreements out there? I haven't gotten one person sending in a comment on our live stream here.
Hey, what
I
can I
think
say?
that's because we must be so lucid that there's no reason that they could possibly have for answering a question, asking a question. All right, let's do
We'll revisit medical boards here.
yes, this is we need to get this clearly in your head. And so this is one more attempt to go through the list of things that you ought to be aware of or you not should do when you get involved.
Well, this is a hot topic in emergency medicine, medical legal stuff, because it's so common. This is medical board actions are more common than medical malpractice actions. So again, some advice from lawyers about how to handle medical board actions. So the threshold for patients to make complaints to state medical boards can be really low because you don't have to have a lawyer to do it. Anybody can make those complaints. It can be patients, it can be family members, it can be, other medical providers who just don't like you. And medical boards usually investigate all of those complaints. There's in this article from Medscape by Lee Page in February, there's a 10 things not to do in a medical board hearing. So we'll kind of I'll review the first 5 of those here. And then Rick, I'll give you the last 5. So first of all, just not responding to the complaint is a big mistake. You get an investigation, you might think that this is not worth your time, but you pretty much have an obligation to respond. So respond to the complaint. Kind of with that, not recognizing that it's serious. So when you do respond, you need to provide as much information as you can to support your response, whether you need to go back into the chart, pull out whatever information you can. You might need to kind of talk to other people that were there, the nurses, other people in the department who can remember that interaction and provide all that back to the board.
I think that the idea that this idea that the board is not your friend really needs to be on the forefront of your brain, because you'll be interacting with other physicians, and you think that this is a peer-to-peer. We're friendly peer-to-peer, but this is not friendly. These people are out to determine whether you went beyond the practices or privacy, or you did something improper, or you touched somebody improper. All of that stuff is big time stuff.
Right. So that was the next point. Don't come in with the assumption that the person investigating it, just because they're your peer, is on your side. Really the opposite assumption is true. So really come in with the assumption that they think that you did something wrong. But don't approach it with anything but complete honesty. So be honest, be forthcoming. If you do anything but that, you can really put your license in jeopardy really quickly. Even if the complaint is pretty minor, don't withhold anything, especially if that information is requested. You can get in big trouble if they ask if there are any previous complaints or something, and you think, oh, I hope, it's in some other state. I don't think they're going to find it. You've got to give it to them. And, don't try to pretend that you did everything right. If you feel like, oh, yeah, I could have done this better, should have done this better, you can own up to that. Doesn't mean that you're going to get your license revoked or something, but just be honest about what happened. But at the same time, you don't have to provide too much information. You don't have to, go off about how this patient was super annoying and, you don't want to go back into the room because they were driving you crazy. Some of that information is not going to help you. So, be honest, but don't provide information that's irrelevant and can just make you seem like you're whining or something like that. Unnecessary issues don't always help you.
This issue about if they catch you in a lie, it may be a relatively minor thing, but if they catch you in a lie, that lie in itself basically is a reflection of unprofessional conduct. And Martha Stewart went to jail not because she had some inside information that related to trading. She went to jail because she lied to the feds. That was her crime. And you've seen other people who've lied to the feds, like all of the guys who worked for Trump. All of them who went to jail, it was because they lied to the feds. So lying in it of itself becomes a problem, even if the situation is medically not any big deal. Um, Never contact the person who has made a complaint against you. That is a no-no. Well, the same thing applies in real court. You would never basically talk to somebody who's made a complaint and you're in court on the other side of of the of the the case. Greg, any thoughts about anything that's covered so far?
Well, I think the first point that has to be made is this is a process. And you have to go with the process. You have to kind of do those things that are necessary. All doctors feel two or three things: offended that someone would think they didn't do it right. How could they do this to me? Yada, yada. Bottom line is the best thing you can do is play the game correctly. Show up, be represented. Don't think that you don't need to have an attorney, because you do. And there are attorneys who do just this kind of work. It's important that we take it seriously.
Yeah, that this is listed as number 8. I would think that getting an attorney is like number 1
Yeah, yes,
to help you
exactly.
create the response to the complaint against you. I know a ER physician who became an attorney, and he did work just like this. And so he knew the medicine and he knew the law, and you combine them together, you could make a powerful response to the allegations against you. And you don't want to have anything but the best response that you can generate, because I would think that you can nip this in the bud relatively easily at the beginning. But once they have these ex-policemen and detectives who are doing this investigation on you. This is and they don't necessarily have to follow the rules of evidence or law in terms of of going after you. um, Simply signing a consent agreement without understanding what you're when you sign a consent agreement with the medical board, it says that's in essence saying you agree with what the board's decision is and its remedy, and precludes you from making a counter offer. By the time you are signing something, you're done. So this is clearly something that would need an attorney to help you on, somebody who knows the medicine. Um, the other one here is not requesting hearing. You're entitled to a hearing. Some states have high standards for taking action, so they're looking for clear and convincing evidence. Other states not less so. And a hearing will make the world publicly. You can state your case, and your attorney is able to respond to the hearing. I think that's kind of like standard fare, that hearings are conducted in any cases where you disagree with what the board is saying. Um,
I think
get
a couple
Go
points on
ahead.
that. So the not hiring an attorney, I thought, this was news to me when I learned it, that there are, attorneys that specialize in just this, just representing physicians in front of the licensing board. So, I think that as a physician, when you get a board complaint, that can be really overwhelming. You don't know where to start. Well, where to start is going to the attorneys that specialize in representing physicians in front of the licensing board. So you could literally ignore everything in this list that I just reviewed, that Rick just reviewed, and all you go is go hire an attorney that represents physicians in front of the licensing board, because that's their job. So
That's
it's
exactly right. We don't need to read this list.
yeah, honestly, it's such a common thing. That's really like the take home point. So if you get nothing out of this, get that out of it. They're attorneys that's all they do.
Well, Mark Calvert, one of the attorneys that we've talked to periodically, he represents physicians in front of the medical board routinely, because, as you mentioned, we had this from, I think it was last year. It was something like in Indiana or in Illinois, the rates of board actions were like 8 times greater than the number of malpractice suits. So you're right that that's much more risky than getting potentially sued. And if you get sued, you have insurance for that. If you get in trouble with the medical board, you don't have any insurance for that. You might get in some way limited in terms of your practice. And once your practice is limited, that has to be reported to the database, and it gets to be a mess. And lastly, don't get upset at the board officials, because if you piss them off any more than they already are, that it's not going to be in your favor to get arrogant or show your anger. This kind of gets Spock-like when you're dealing with these people. Be polite, answer the questions. Um, I'm not quite sure where you would necessarily find lawyers who do this, Rachel. Is there some kind of directories of lawyers, or how do you go about this?
I think just Google, honestly. I went through this with a colleague recently, and we just Googled, and the alternative would be your institution may have access to this.
Dr. Google helped you out here.
Yeah, but yeah, that actually was pretty easy on Google.
I guess there's an issue though, is how comfortable you feel with them with regard to their competence. But I guess you can get a sense of that after you have some kind of conversation with them, and they basically tell you, I do this all the time, that kind of thing. How about abdominal pain in a post-op patient, Rachel? Here's a case.
All right, we'll jump to a case. So in this case, a patient was in a rehab facility after having a knee replacement, and they began to complain of right lower quadrant abdominal pain. So it looked like an emergency physician saw the patient, got an abdominal CT scan. That was read as negative for appendicitis, but the radiologist said they couldn't rule out a colonic obstruction. So not quite what they were looking for. But the emergency physician said, they had a colonoscopy scheduled for the next day. Thought that would be appropriate, kind of help them figure out what's going on. So the patient returned to the rehab center, didn't get any records or reports. Again, the emergency physician said that colonoscopy should be just fine. Patient went back, told the rehab doctor CT was negative, I'm good to go. Patient was given some laxatives by the rehab doctor, in prep for the colonoscopy. Abdominal pain worsened. Patient went back to the ED because of their worsening pain, and at this point was found to have a colonic perforation, and the patient died. So I think, Rick, you've pointed out some lessons learned here. There's probably a few lessons learned. Maybe one obvious lesson learned: transitions of care are notorious setups for errors, things gone wrong. And in that same vein, have a protocol regarding transfers of records and kind of expectations when sending patients back and forth between care facilities. And, be sure who's following up with needed care. None of those things happened with this patient and had a really poor outcome.
It's hard to conceive that records would not be sent back to a patient who's going back to a rehab facility, that there would no paperwork being sent back, or even a phone call to the doctor would be great. But usually at rehab facilities, there's not a lot of doctors floating around. The patients are just kind of getting a little PT to get their knee moving again, and that's about it. So there's not necessarily anybody to call. But you call the patient's primary doctor. You could, but it would just be weird. When we had patients, we used to send copies of their lab tests and their X-ray reports, whether it was a preliminary reading or a final reading, preliminary reading by us, final reading by the radiologist. Now everything's on a computer that most people are linked up to, and you can just get all of that stuff. But somehow somebody needs to know to read it. And so maybe in some ways paper was better than having all of this stuff on a computer, unless you knew that somebody's going to look at it. And especially if you need follow-up in a short period of time, like the next day, you would think that you would definitely know who is going to do that follow-up for that patient. So my brother's wife's mother, I guess she would be called my sister-in-law.
Yes.
She blew out her colon and died. And her problem was chronic constipation because of opiates for this, all her compressions of her vertebrae. She was in this severe pain all the time. She was on opiates, and basically the opiates were responsible for her death. Ultimately, you wouldn't think of it as constipation. The next thing you know, you obstruction. The next thing you know, you've got a perforation, you got peritonitis, and you die. And that's what the result was for an old person. She actually wasn't that old. She was younger than I am. uh, she died from this thing, and so I think you have to obviously be careful and know that opiates in an older person can be not your friend.
Back to this transfer issue. I could see this actually happening in a variety of scenarios where the paperwork didn't get sent back. And it makes me realize, I don't really follow what happens with that paperwork. And I could see it, getting kind of handled, not all that carefully. And I don't actually think that a lot of the care facilities are linked to the same EMRs that our hospitals are linked to. I think increasingly a larger portion of hospitals are able to see their records, but I don't think that's necessarily true of these care facilities. They didn't have the same meaningful use incentives that the hospitals did. So, I can imagine a scenario, say a patient came in and was diagnosed with diverticulitis or, something else that would be a relative contraindication to a colonoscopy. And maybe it wasn't communicated that they were supposed to have a colonoscopy the next day. And, those records didn't make it back and they went and had their pre-scheduled colonoscopy the next day. Yet somehow that's still on you as the emergency physician for not, following through on that communication. You made that diagnosis that identified some relative contraindication to the procedure they had the next day. And, didn't link those two and the patient died, you're still probably going to be hooked into that lawsuit, or you could be.
Yeah, you could blame it on the nurses and say, well, that's kind of their responsibility to package that stuff up and send it back with the patient.
Captain of the ship.
But I was going to say, ultimately, it's your responsibility. You just delegated that responsibility, and it didn't work out.
Right.
Can we talk about the sobbing plaintiff attorney and medical medical expert?
Please. Yes, please.
The defendant physician claimed the behavior of these two people, the attorney for the plaintiff and the medical expert for the plaintiff, they tainted his trial because the plaintiff and the family members physically cried while these people were giving their testimony. There was a delayed diagnosis of ovarian cancer in this case. The expert was describing what the patient was likely to go through during their process of dying. So as this person describes this, everybody in the family is crying, the expert is crying, the attorney is crying. And do you think that prejudiced the jury at all? I kind of think so.
Yeah, wait a minute. That's part of a lawsuit, Rick. I mean, before we start sort of immediately jumping in on this thing, remember that they're going to be regular old people who sit on a jury and they get to see these family members. And this wouldn't be the first time someone has cried during testimony in a medical malpractice case.
Yeah, but how about the attorney and the expert? They're
you
crying.
know what?
Everybody, the judge is crying. Everybody's crying. The bailiff.
I think they're all allowed to cry. I don't think there's a rule. I mean, maybe we can get our attorney here to tell us, but I don't think that that's necessarily a reason that the case has been decided inappropriately.
Oh, it's theater. Of course not.
Of course not. Yes, it's total theater. And the bottom line is theater is a part of all of the process. And I think this doctor should have learned to cry better. And he could have had his own cry fest during his part of the case. I don't know what somebody's going to expect them to do. There will be crying in trials.
Well, you can envision the closing argument in this case, where the the plaintiff's attorney is sobbing in front of the jury as he sums up the whole affair. The motion for a new trial was denied, as you might have anticipated, Greg, as you suggested.
Yes, exactly.
However, this is kind of interesting. The award to the patient was substantially less than expected. So, maybe that had they said, okay, let's give it to the patient, but let's not give too much money. They died. 1.3 million is fine for dying.
Yeah.
So
Go ahead, Rachel.
I was gonna say, speaking of theater, so one of the most memorable stories my law school mentor told me, back when he was a big highfalutin lawyer, worked for one of these top 10 law firms in DC. They, did training for the trial lawyers, and he never made the cut as a trial lawyer because he wasn't like built enough, and it was just the manly men that they put in front of the juries because it was,
or
the
womanly women.
Yeah, for the right people maybe, but
right.
they were very much like profiling the people they wanted to put. So you had to be like, tall, handsome, built, and they literally, I kid you not, these were these like giant, trials, these multi-million, billion-dollar trials that these companies did, where they had like teams of, dozens and dozens of lawyers that were billing like ridiculous thousands of dollars per hour. The trial lawyers would stuff their pants to make themselves look like they had a bigger package because that was more appealing to the jurors. I am not joking you. This was part of the like profile of the lawyers to stand in, so that in front of the jury, they would look like more whatever, authoritative. So literally the lawyers for these giant firms were up there with socks in their pants or whatever they used to stuff their pants.
Well, Greg wouldn't need to do that.
Nope.
Not at all.
No.
But this is not a joke. Like, this is something you think you see on a movie, but this is real life. I mean,
Yeah.
they're actually doing this. It's crazy to me.
Well, they probably had studies about what jurors respond
right.
to, and they determined the size of your package was one of the things that made you a manly man.
Well, and believable, and made the jury, trust you more, or whatever. And so, yeah, it was absolutely just based on all these studies about what sways the jurors. And apparently that's more, meaningful than the facts.
It's really weird. So we're waiting for all of these questions to come in from these two people who are listening to this live. And what do I get? Doc accused of killing 14 patients. Verdict is in. I guess now, can I click this to see what the verdict was? Because that's the headline. Did he kill him or did he not kill him? With opiate overdoses at a Columbus, Ohio hospital ICU over a 4-year period, was found not guilty by a jury Wednesday. This was a person suspected of end of life, taking the matter into their own hands after a 7-week trial, for crying out loud, featuring more than 50 witnesses. They declared Dr. Husel, Husel, not guilty on 14 counts of murder and attempted murder. Okay, there you go.
Well,
I mean, that's 7 weeks. My wife went to a trial that went 7 weeks in Pasadena. It was a retrial of a guy who was accused of shooting to death somebody else. It was a gangbanger kind of thing. And the retrial went 7 weeks. And of course they convicted him.
Yes, exactly.
Look at all that time and money. Fortunately, she still got her partner share, even though she wasn't doing any much in the way of work during that time. Is there anything else that we want to talk about in this sobbing? No? Okay. How about dealing with offensive or impaired doctors? Greg, I bet you've had a few impaired or offensive doctors during your few years of practice.
Yep. Let me just say to start out, when you are the head of a department, you're going to hear everything from everybody and their cousin and their wife and their friend and their neighbor about this doctor did this or that in the department. I think the first thing the chief of the department has to do is take a deep breath and sit back and relax and try and get the information as correctly as you can. But I will say this, that one of the toughest jobs of being the chief of a department is having to deal with personality interactions between patients, the docs, the families. It isn't simple. And I think, as I look back over all those years I was head of a department, that was the toughest part, was because we don't all view it the same way. And what should be said and what isn't allowed to be said and all these things, it becomes a difficult situation for everyone involved. So anyone who thinks being chief of the department is just getting awards at the end of the year, no, it's having to deal with all the families.
Yeah, I think that this is tough. I was the chief for 25 years, and there are two things that you had issues with: doctors who may have crossed the line. I remember one of our doctors was accused of doing too vigorous pre-employment physicals. And, I didn't know, because they were always done alone by the doctor in the room doing a physical. And these women would be in gowns, and what their breasts have to do with their ability to work or do a job is pre-employment physicals, I think, are pretty nutty in the first place. Unless you're have some specific reasons to do that. So I didn't even know that this doctor was, touching anybody's breast, no less. Anyway, so that happened, and this doctor basically ultimately was relieved of his duties because several women complained about him, and frankly, he was let off easily, because he could have gotten into a lot more trouble, and maybe he should have gotten into more trouble. Maybe I should have been more aggressive with this. This is not the time when I did this that, I think the idea of behaving appropriately in front of women or with women was not nearly as prominent as it or fair as it is now, I think. So I'm trying to excuse myself for my behavior in this case. They also have this thing about this advice from this column that was also in Medscape. You want to go through some of that, Rachel?
Sure, but do you guys want to talk about the case that the commenter put, the not guilty on this physician who?
Yeah, go ahead.
So I looked it up while you guys were talking. I actually hadn't heard of it before, but it's all over the news right now. Have you guys read about it all?
No.
So
it's the first I've heard of it.
So it's interesting. It was an Ohio physician who, I think I was just briefly kind of ran through it quickly, but an ICU physician, it looks like, who over the course of, 3 or 4 years, initially was accused of murder, 25 cases of murder, for overdosing people on fentanyl and morphine with the intention of hastening their death, which is not legal in Ohio. And then eventually that count got dropped to like 14 deaths. And in all of those 14 deaths, they were all related to fentanyl, and all the doses range from 500 micrograms to 2,000 micrograms of fentanyl at a time that were given to these patients, who then, rapidly died. All of them had terminal illnesses, and he was acquitted of all of those charges based on the kind of determination that, it was impossible to say that the providing those medications actually hastened their death. You know, they were so close to dead anyway. But dang, those are high doses.
Dang, those are high doses. Uh, you know, this is where one of those cases, like, it just doesn't pass the sniff test here. But this is maybe artful lawyering on both sides of this case. The fact that it went 7 weeks. I mean, somebody put a heck of a lot of effort into nailing this doctor, and it didn't happen. But there's other things that maybe this doctor's contract will not be renewed if they're a independent contractor or something like that. So,
well, so to point out, this was a criminal case. So this was the murder case, murder charges.
Mm-hmm.
So the civil cases have not been brought yet. And, for criminal cases, the standard of proof is much higher.
Yes. Mm-hmm.
So yet to be seen how the civil cases play out. Like OJ was not guilty in the criminal cases and then had the giant verdict in the civil cases. So
which he's still
happen.
not paying because he lives in Florida, where if you are sued, you still own and you own a house. They can't take your house away from you. So you can just buy a multi-million-dollar house, park some cash in that house, and they can't take your house from you. But that's Florida.
Yeah.
That's why OJ, I think, is there for sure. Well,
anyway, it's fascinating because I don't think there are a ton of cases around like end of life. And this is something that could come up in the emergency department. This specific one wasn't. I want to reward the person who's listening and actually putting in a question, by discussing it. But, we get in a scenario where we're giving meds at the end of life, whether it's fentanyl, morphine, Ativan. And I think that, it's always up for debate whether we're hastening death with that. And I think the argument is it doesn't really matter if we're hastening death, if we're providing the comfort, if that's our primary goal. If we hasten death, it doesn't really matter. But
yeah, it's listed as comfort measures, and
right.
The comfort measures may have a side effect of hastening death, and the family's aware of that, and everybody's into it. That that seems to be a reasonable approach. It doesn't sounds like this was a kind of like his own decision to do this. And you've heard of these angel of death cases where nurses have given medications that have caused people's death. So yeah, I think I mentioned before the case of the anesthesiologist in our hospital who got criminally charged for neglect, and the nurse who gave the Versed instead of the gave the vecuronium or instead of the Versed. Basically, she's up for her sentencing is May 13th. And so everybody's going to be watching that. But you already read a lot of papers regarding nurses saying, oh, well, am I next? If I make a mistake, am I going to get criminally prosecuted? And obviously, in this case, there's two sides of it. And people, I guess, think that her behavior was such that it was worthy of a criminal trial, at least. But so I don't know that you can necessarily think that that's a big opportunity for nurses to make mistakes. I think it was and get similarly prosecuted. Anyway, what about this 3C things that C. Lehman, who wrote this article in Medscape back in November, she said that three C's.
All right, this is for me. So the article itself was based on a presentation at the 2021 MGMA conference by Deborah Ferris, who's the president of Practice and Liability Consultants. Basically, the article talks about how just verbal harassment or bullying can lead to large dollar awards against organizations that knew about the behavior but didn't stop it. And basically, offending physicians need to know this. And there are a few tactics that they put forward for dealing with disruptive physicians. So 3 C's that are suggested. First, confronting it. Starting with just an informal discussion, about that behavior. When I think ideally at the time of that behavior, when you first see it, like, hey, what you're doing, we really can't do that here. We got to find a different way to, behave in that situation. I think the closer you can do it to that behavior, the better, and kind of the less awkward that confrontation is. Correcting that behavior. So seeking a written apology.
I think that's a good idea. I mean, obviously when this happens, so somebody is on the receiving end of this bullying or harassment or inappropriate comments. And so sending a formal apology acknowledges in writing that an error was made by this person. Of course, they're sending it because everybody's afraid of a lawsuit here.
Right. And on the same side, the organization should put something in writing to document that they are addressing this behavior, which can come in the form of kind of a letter of admonition to the person who's behaving badly. And then kind of a third step, if that's not working, is to engage in some kind of formal coaching or counseling for that person to kind of more aggressively try to modify that behavior. If people are still resisting, you can do one final letter, basically warning them of the consequences, followed by termination.
They also have this idea about you mentioned doing it as soon as possible to the incident, because if you did it, if you say, Frank, yesterday when you did this with this patient, it was probably not it was not really the way to do it, and you offended them, etc. Obviously, that all of this takes courage. But if you're in any kind of a responsible role as a leader of the department or something like that, you don't really have any choice, because you are now acting on behalf of the hospital to act as their agent to try to resolve this problem. And I told you about this big case where a anesthesia resident was bothering an emergency department resident, and the department is alleged to have not done anything about it until it was well down the road. And so she sued the department, the doctor who was annoying her and or harassing her. And ultimately, the anesthesia resident had to go to a different hospital. The doctor who sued won some kind of an award, and the department chairman also wound up leaving the hospital as well, because basically it was perceived that they didn't do something that they were supposed to do to protect the hospital, the patient. I mean, and the two residents. They should have been something should have been done, and that was the whole allegation. And it's just easier to sweep a lot of this stuff underneath the rug, but you could wind up paying big not only in terms of dollars, but in terms of your position at the hospital. The other thing that they mentioned here is you have to be consistent. Everybody has to be held to the same standards, whether you're a chief of staff or any kind of physician or nurse or anybody else, and that other employees will want to see that, in fact, this code of conduct is maintained for everybody.
Yeah. And, to that end, the code of conduct should be in place and shared, from the beginning of employment during the interview process. This is something that, from the employee's perspective, has existed for all time. It's not kind of being created as the employee starts behaving badly. It's just kind of, it's been laid out from the beginning.
In that regard, having this idea of fairness in this code of conduct. I wonder when a new doctor comes on staff, why we're not asked to sign off on a book that I've read the code of conduct. I've read what are the reportable diseases in this state. All of these kinds of behavioral kinds of things that can get not only the doctor in trouble, but the hospital in trouble as well, because what are the reportable cases to the state with regarding lapse of consciousness or something to that effect. And in California, there's a very specific law about reporting lapses of consciousness. And if you don't do it and somebody hurts somebody, you didn't follow state law. And that state law was also part of our um, our manual of things that you have to understand and agree to when you come on to the department. I think that, what if a physician comes in from another state? They don't know anything about California's reportable diseases, reportable conditions, any of those kinds of things. And yet I don't think any doctor has to kind of sign off. And yes, I've read all of the codes of conduct and here's my initials underneath each one. Rachel, did you ever have to do any of that?
I don't know. It sounds kind of familiar, actually.
I
Familiar,
was-
but I don't remember doing it.
I was going to say, Rick, it was so long ago you did it in the state of California. I mean, I'm sure, but yeah, I'm sure they had something for you to do, but things really have changed, and behavior in the departments, what you can and can't get away with in talking to other personnel at the hospital. I think that things have changed a light year since I started in the hospital, and it's probably a good thing. But I honestly think this is getting better. I think there was more outrageous physician behavior and comments and things like that in the past than there are now. I think it's better.
Yeah, they used to have all these doctors acting up in the operating room because they were these prima donnas, and the nurse didn't hand the right instrument immediately or something to that effect. That's
Yeah.
not tolerated anymore. And I think that if I was the chief of staff or chief medical officer or something to that effect, I think that physicians should acknowledge the key policies that the hospital expects them to uh, uphold. Because what happens if you're in a position of saying, well, they never told me I couldn't do that. Well,
Yep.
maybe there's no proof that they told you that you shouldn't do this or that. This is our standards of behavior, or this is what's going to happen if you come in and you're expected to be intoxicated. This is what we're going to do. I think that those things are perfectly reasonable. You may be, when you sign up for a hospital and you get all of this stuff that you're supposed to acknowledge, I don't think most people have any recollection of signing any of this stuff, as reflected by Rachel's lack of any awareness that she's agreed to any of these things.
Right.
I mean, we
exactly.
definitely have some of that. I remember, like, we have a dress code. We can't have, at least when I
Oh,
signed,
really?
we couldn't have like exposed tattoos, couldn't dye our hair. Some of that they've relaxed, but we had to still wear pantyhose when I signed my first contract at Mayo, or like signed. It wasn't a contract, but when I first took my job at Mayo.
Wow. Do they still have a dress code?
They have a dress code, but it's relaxed a little bit. Actually, when they first got rid of the pantyhose requirement, there was like pantyhose in the trees in Rochester because people were so excited. It was only a few years ago, but people felt so liberated. It was pretty funny.
Well, don't they keep you warm?
Yeah, I
I
still
mean,
like
you
them.
need them in Rochester.
Yeah,
I
I
think.
know. I think, yeah, but it was it was symbolic.
Yeah, I think that there's all of these studies about what patients think you ought to look like, and they're easy to do because they just have pictures of this is a doctor wearing scrub, this is a woman physician wearing a lot of jewelry, this is a white coat, no white coat, and and they show pictures of these people to people on internet surveys, which again, very easy thing to do. And there are some trends in terms of what the expectations of people are. I mean, they don't necessarily do them for the emergency department specifically, but there is a trend, at least in some, that they like white coats. I think particularly the older patients are expecting physicians to look like, what their expectation of a physician to look like is. Although I'm sure they view scrubs as acceptable, they might prefer a white coat. But I think you want every advantage you can. And I think one of the advantages that you can in terms of establishing your credibility, particularly for women, so they're not, confused with the nurses or something like that. I think a white coat with your name on it that says, Mayo Clinic Emergency Department underneath would go a long way in terms of. Plus, Rachel, you look like you're 15. I mean, come on.
Yeah, yeah.
So I could see why you should strive to kind of get everything in your advantage when you can, and that you will get. I know a physician. You know the same physician. He's got a tattoo from his wrist to his shoulder,
Yeah.
but it stops at his wrist, so patients, can't see when he's wearing a long shirt or anything like that.
Right.
What he's chosen to do.
Yep.
Should we move on? Do we have anything further to say about this?
Well, there are a few more points in here. Again, I think another point that is worth saying is if you're, get to the point where you're going to fire somebody, get an attorney first, make sure you've you've checked off all the boxes, because it is not uncommon if you fire a physician that they're going to hire an attorney and, kind of fight that decision, or, it turn into a wrongful termination lawsuit, especially if you haven't done it in the right way or given them kind of due course. And so, if you are going to make a life-changing decision for somebody, invest, however much it costs to hire a lawyer and do it the right way. I know that we kind of sound like a broken record here, but these are situations where lawyers, are going to save you a lot of headache and hassle down the road.
Well, yeah, I think it's a big deal to terminate a doctor because when that doctor goes to get their next job, uh, you don't expect a nice letter of recommend. The letter of recommendation will be, yes, the doctor was on the medical staff here between this year and that year. That's it.
Yeah.
No,
Um,
it's a huge deal. And, likely that doctor's not a terrible person. They just, didn't hold up their end of the bargain one too many times. And it's not a fun thing. And so you've got to dot your I's and cross your T's. And you probably did not get the training on how to do that in medical school. So, pay $10,000, $20,000 for a lawyer to do it for you.
Plus, the hospital probably has its own HR department. They know how to do this stuff. The hospital has its own lawyers, and I think if you're an employed doctor by a hospital, then you have the hospital's resources behind you. If you're an independent contractor or something like that, that's kind of a different story. Want to move on?
Sure.
Oh, yeah. Let me do this thing about impaired doctors. The doctor who's getting a little too old to be practicing and is getting more forgetful than usual, or something to that effect, or even going to a doctor who is acting as if they're really they're just acting depressed. They have their affect is flat. They don't seem to have any joy in their work. I had an interview with a doctor who Greg, Louise Andrew.
Yes,
Yeah.
of course.
Louise is a MDJD who had a lawsuit against her, which helped precipitate the fact that she's about our age or less, or somewhat less, but she was very influential in the leadership positions in ASAP. But she ultimately went into supporting doctors who've been sued through this process, just like Gita Pensa, who
Yes.
the who's also doing the same kind of thing, because
Yep.
had such a horrible experience being sued that she spends a lot of her time now, helping doctors get through this process. Well, anyway, we were talking about it, and it's going to be on MRAP in about 4 months, is about physician depression and physician suicide. And one of the things that comes out of this, especially if you're a leader of a department, is you really need to approach physicians who are acting like they're in the dumps, and say something to the effect that, you really seem depressed. Can I, you want to talk about it? Can I get you any help? that's the job of the department director to do that. And you may be saving somebody's life in the process of doing that. Um, they look at the physicians who commit suicide. Very, very few of them are under any kind of medication that would be helpful. So they've not gotten any help. Um, and so the idea is, if you see something, what's the worst thing that they can say? They can say, mind your own business, or they can say, no, I'm fine. But if they say mind your own business, as the director, you have to say, well, if you're not depressed, then get with the program and start smiling and start acting like you care.
Yeah.
'Cause it's part of the job, whether you like it or not. But if you're, if there's a reason that you're down in the dumps, there's exogenous depression where people are depressed because they're going through a divorce, they're going through a big IRS audit, they're getting sued, they have all, the kids are having problem at school, whatever it is, those kinds of things. If you're bringing it into work, it's the director's responsibility to kind of see if that behavior can be fixed. There's also this idea of being fit for duty. We did this thing, Greg, a while ago where the medical staff was having mandatory neuropsychiatric evaluations for doctors over a certain age when they're renewing their credentials. And people, that got to be a really kind of sticky wicket. And do you know at your hospital, Rachel, or any hospital, whether physicians over a certain age are required to go through any kind of neuropsychiatric evaluations?
I'm not aware of any actually, but it makes some sense.
Well,
I'm
it it does, but what these papers basically said is you can't do it by age alone.
yeah.
You have to have some other parameters to get somebody to go through that process. And then again, it has to be done by a third party, et cetera. All of these things, the rules about age discrimination come into play. You better know what you're doing is I guess the gist of this here.
I'm
Um,
thinking about the conversation right now about Dianne Feinstein, which is in the news a lot,
yes,
right?
right.
It's really relevant and super sticky. And I think there are a lot of people that have concerns about her mental capacity and ability to do her job. And, it's still very much a very sensitive topic.
Yeah, it is. And there was a judge on the Supreme Court. I don't recall which one it was.
Yeah.
Who was falling asleep, who was incontinent of urine in there, and just basically the idea that you have a lifetime position and it's your call when you want to stop.
Mm-hmm.
There's a lot of these judges who have probably should not be deciding these really major cases when they're as old as they are.
Yeah.
What do you think? Should judges have a lifetime term on the Supreme Court?
Oh, yeah.
Oh,
You got to be
not a,
careful. You got to be careful here, Rick, because
no,
it's a system which
you get
has
a 10-year
worked.
term. That's
What?
it. You get a 10-year term. We'll give you 10 years. We'll give you 15 years, but then you're out.
Yeah.
Anyway, what about the aging doctor who won't retire? Basically gets a little uppity
Oh, yeah.
about it.
I guess I was jumping ahead and I was looking at that section in reference to Dianne Feinstein.
Let me just tell you that in most hospitals, the docs who are getting to that stage, the other docs cluster around, talk to them, do various things, take over other cases. I haven't seen it as great a problem as some of my colleagues have. I think that most of our docs get some input from other members of the department when they need it. And I really think that it's not as big a problem as it may have been in the past.
Well, that sounds like a good way to do it, as long as that, the doctor's, accepting of the advice. If they're not accepting of the advice, you kind of go down this path, which does have neuropsychiatric evaluations in it, and your employment agreement may have said that that would be a requirement for you to submit to that under certain circumstances. So there are all kinds of things that you need to read before you start your job.
Yes.
I think, Greg, that also when we started in emergency medicine, which was in the 70s, a lot of these doctors now are in their 70s and are generally past their retirement age. If and so this thing may be coming up more than not, because there are doctors who are clearly older than us who are still practicing, and whether or not that's a good idea or not is another matter, because I would think that if they make a mistake, the it's more likely they will be sued. And even Biden is being accused of not being able to pass a neuropsychiatric test.
I know. I listen. We we've never had a time when there wasn't somebody in a position of authority who that question hasn't come up. Is their age, their years, their this, their that. I think in general, Rick, we handle it pretty well. I've been involved in that at my own hospital with two physicians over the years. And you know what? I think we did the best we could for those physicians and their patients. I mean, we did have to talk to them and about their plans into the future as to what they were going to do, like tomorrow and on Friday, that kind of thing.
Is that what it's pack your box
Yes.
and leave the red stapler behind.
Yeah, but you kind of wonder where you put that hammer. Where do you say that somebody, you got to retire now? Well, some of those people are pretty good, and you got to be careful.
But you also
I
have to remember that those people are probably been covered for to some degree before that conversation occurs.
Yes.
I think that's actually a really interesting topic. I haven't really spent much time thinking about it, but I think it's going to be, as you point out, Rick, kind of a growing issue in emergency medicine in particular, because we're just maturing as a specialty. So we're kind of seeing our first generation of people reach the age where maybe this is becoming problematic. So, and then just in general, 30, 40 years ago, people really weren't wanting to work into their 70s because
Right.
Life expectancies were different, retirement age was different, and now we're really pushing that for a lot of reasons. COVID, physicians have they've kind of extended their retirement age. Telemedicine has allowed people to extend their retirement age. A lot of people, not in emergency medicine, yes, but also other specialties, have started being able to work from home. So I think we're going to see physicians working longer into their 70s for a number of different reasons. And I don't know that we've really addressed this issue in the systematic way that we probably need to. And maybe we haven't seen it as, a huge issue yet, but even, a few dozen physicians out there working, being incompetent, working at age 75 it's a lot of patients with incompetent physicians.
Working at what age?
Throwing an age out there.
Older.
Oh my
physician-
God.
older
Did you
physician.
hear what she
It was
said,
like
Rick?
a freaking spear through my chest with that one.
I'm
Oh,
just
man.
saying, but like,
No, I agree.
Yeah.
I do agree with you. It is going to come up, and you really need to be careful about it. And Greg's way, I think, is really the way for colleagues to do this. But you hope that they get the message. But
how do you even recognize those colleagues? That's presuming that you're working closely with them enough to recognize it. And I
Right.
don't think that's really the case anymore. You're not seeing their patients it's not the same work environment. I have no idea what my colleagues are doing.
Really? I mean, you have more than one physician on at a time, don't you?
Yeah, a lot of the time, but you're never in a room with them. We don't have curtains.
Yeah. Okay.
Maybe you see their bounce backs, but and when you get into a telemedicine environment, there's no overlap. So there are definitely environments where you can have a physician who's working, pretty much in a silo.
Hmm. Yeah. No, I think you're right.
Yeah.
Let's stop here. We have a long thing we want to do next time about. It's another doctor who was sued um, because they sued because they were believed to be wrongfully terminated, and we'll go over that case next time. It's really an interesting case. It's really, in some ways, it's kind of like unbelievable, but we'll go through it and we'll get into the thing about at will, employees being hired at will, and what does that mean? Because I think a lot of you are hired at will, frankly, and that was one of the issues that ASAP is dealing with is you know having some recourse other than being said, well, we're done. Thank you very much. I wanted to, Greg, did you have a wine for this month?
No, didn't you have
Yes,
a?
yes. Well, in the
Well,
event that
that's
I just happen to have one here. This was sent to me. Uh, I'm blocking the guy's name who sent it, but in any case, this is from the Wall Street Journal of all places. Something that I read regularly, or the wine column here.
right.
This is about what they call they're called petit chablis, petit chablis, and they point out that the reference books, when they talk about petit chablis, it says lighter with fewer flavors than chablis, but it's cheaper. But does that sound like a wine you'd want to drink? No, not according to the Wall Street Journal. But
Yes.
this paper, this article says, there's some of these that are really terrific, and not all should be put into the same category here. And they wanted to point out one in particular, fresh and wonderfully well balanced 2020 Domaine Vincent d'un Petit Chara, $20, as well made as it's well priced, as well made as it's well priced. So there you go. For those of you who are into the wines, Petit Chablis, particularly the 2020 Domaine Vincent d'un Petit Chablis, $20. Obviously, it has to be at Costco. And if it isn't, I'm not interested. Thank you.
Yes.
Any further matters to come before the jury?
Nope.
Rachel,
Good.
anything going on?
Nope, we're good.
Okay. See you guys. We'll talk with you next month. wrbukata@gmail.com. wrbukata@gmail.com. Send us a note. Tell us what you think, what other topics we had to cover, and look forward to hearing from you. Bye for now. Signing off. Bye, Greg. Bye, Rachel.